Hello, my name is Patrick Hurl, and I'm going to be the narrator for Group 7's project. Group 7's project involved a robbery in Arizona, taking place from June through October of 2014. The suspect was one Lee Daniels, who robbed a series of businesses, concealing his identity by wearing a bandana over his face, a hooded sweatshirt, and some gloves. He kept one hand concealed in his pocket as if he had a weapon. While surveillance videos captured the robberies, no victims could identify him in a photo lineup. However, Daniel's neighbor gave a tip to law enforcement, suspecting that he had been involved in the robberies. Daniel's addresses turned out to be close to the business in question. He had not told his parole agent about his new address, and also a search of his vehicle and house showed that there were two pairs of distinctive shoes along with clothing that seemed identical to what was worn during the crimes. All told, Daniels robbed 9 retail businesses, the value amount being stolen from each between about $2,000 and $23,000. After receiving a tip from the neighbor, the officers noted that a criminal background check showed that Daniels was on active parole since August of the previous year and did not tell his parole agent about his current address, which is close to the businesses robbed, a parole violation. A search with a warrant of Daniel's house and vehicle revealed 2 pairs of distinctive shoes, along with clothing items identical to what was worn during the crimes. This gave them probable cause to commit the arrest at the time, suspecting him of the robberies. Our group said that as the arresting officer, we did have discretion due to the clothes and the violation of his parole agreement. Our group somewhat disagreed on the next part, prosecutorial discretion, simply on whether Daniels made a confession or not. If he did, it's a pretty open and shut case. However, with merely his record and the similar clothing items found in his house, in conjunction with no eyewitnesses or victim testimony, it would be a hard case to win in court without other pieces of concrete evidence to back up our case. While it would be hard to prosecute for robbery, we could file a charge against Daniels for his parole violation and see if that would make him more willing to confess to the robberies as part of a plea agreement. A defense to robbery in Arizona is that of mistaken identity. If we can't prove that Daniels was actually in the stores, the robbery charge wouldn't stick. Now let's imagine that Daniels did want to participate, or some other piece of concrete evidence came up that forced him to give a confession or plead guilty. In this case, Daniels also had 2 prior felony convictions for robbery and was on parole, as mentioned earlier. So the judge in this case has kind of a tricky situation on their hands with the minimum sentencing laws. In Arizona, a Class 4 felony charge of robbery with a prior conviction has a minimum of 2.25 years in prison or a maximum of 7.5 years in prison as long as that person already has a prior offense. Due to the lack of weapon in this crime and the willingness of the accused to participate and cooperate with authorities in this case, I think it would be appropriate for the judge to go with the minimum sentence of that 2.25 years. Now, the question is, why not just put him on probation, or why not give him some other type of lesser form of punishment? Unfortunately, the minimum sentencing laws do kind of tie the judge's hands in this matter. And also, I think it's important that someone who already has 2 convictions for robbery does do some jail time. But that would be up to the discretion of the judge in that case. Now, Mr. Daniels would have to go back on parole again, and one of our group members set out some rules or terms for when he was on parole. Namely, he had to be employed, to not be involved in criminal activity, provide weekly check-ins to the parole officer, and notify the parole officer if he were to move or change jobs within 5 calendar days. This is important in this case as Mr. Daniels has already broken that in his current parole agreement. So in summation, there are a lot of points in this case and scenario where discretion can be utilized, from the police officer deciding from the tip and from the clothes discovered at his house that was enough to make the arrest, to the prosecutor deciding, with his confession, without his confession, whether to take this case to trial or just to charge him for the parole violation. Now, the judge has a little less discretion on their side simply because of the mandatory minimums. So if it was actually going to be taken to court in Arizona, as stated before, the judge kind of would be have their hands tied behind their back in that case. The parole officer finally would have to kind of weigh Mr. Daniels' previous parole violations when discussing this. And so those are all the types of discretion that kind of play out in this case. So thank you so much for listening, and this was Group 7.